Apology Minister, not Deputy Minister Trapane, and it's women.
And my bay, I can do to my apologies, to my invite.
Now, I'm just but 16 years apologies. I won't look. Can't see what to me look like. Okay, Kisha. I come, ma'am.
I remember that could Busubuyan.
Auntie, ask the look at Pelanin.
September, September.
8 September.
8 September, but Zangi and the date, but I will have to look for it.
Okay. All right, then I'm sure.
Sharp.
Good morning, Sis Pumla.
Good morning, Tapo. How are you?
I'm very well, thanks. How are you?
I'm good. Long time no see.
Hey, you know what? You can say that again.
delay in terms of how many. No, I'm going to report tomorrow. If we say 4 o'clock, all the BT coordinators must report at an NET level. That must be respected.
Good morning, honorable members. How are you?
Good morning, Chair. We good. How are you?
Very well, Honorable Klape. How's Cape Town treating you? Have you escaped? You're muted, eh? You're still muted.
Oh.
Yes. I think your network.
I was saying I'm still coping. I'm still here.
That's good.
Leaving this evening.
Okay. No, that's good. Bonda, what over?
Network at the parks is a problem. I was
What over?
Nada.
You see, we're gonna start having a traditional leadership fight virtually now, with sceneries like that and beautiful traditional home like that. I'm gonna be very jealous now.
No,
how can you outdo vessel like this?
I think we need to, it's just a way to say, let's talk about land, man. Let's give our people our people.
I see. Okay. Morning, Mesu and Isaac. How are you?
Morning.
More Molweni, Dumelang, Tobela, to all the honorable members who are with us on this Friday morning as
Recording
we
in
begin
progress.
our weekend. Let us also send our greetings to the officials of the department who are on the platform, as led by the acting DG Tate Ramasodi. Mayor Reynolds is on the platform. You are most welcome, and the rest of the officials of the department. Let us also welcome our parliamentary legal advisor, Umamusuen Isaac, who's on the platform, to our staff as vibrant as ever, Mamu Nyamza, Mam Kakaza, our content advisors, Mam Kashe, as well as Botobela, Dr. Manenje, our researchers, Mam Kwabe, as well as Mam Papetega, and our convener, Mam Maledu. Let us send warm greetings to all of you. Honorable members, we have been dealing with the Sectional Titles Amendment Bill, the A list, which we went through, and also had the opportunity to get a briefing from Mamo Reynolds of the department on the public hearings they had and the engagements. And also we received further clarity from our legal advisor in Parliament, Mamu Suen Isaac, who will also today just be taking us through the final bill, as we will be also getting into the B list today. Let me, honorable members, without taking much time, hand over to our legal advisor, Mamu Isaac, to take us through the bill.
Thank you, Chairperson. I just need to check if you can see the screens that I'm sharing.
Yes, we see both screens that you are sharing with us.
Thank you, Chairperson. As you indicated, today we are dealing with the B bill. The committee last week adopted the A list. So
The A list, yes.
Yes, from the instructions or the agreement that the committee reached on the A list, we have now asked the printers to typeset the B bill, and I will just indicate the changes as they are in the B bill from the A list. So just to make it simpler, I have projected both the A list and the B bill so members can just follow simultaneously. So this is the A list on my left, and the B bill is on my right. So the first clause that members agreed to was clause 1. And in that clause, we just made a technical correction to make sure that the act is correctly cited. So if members would see in the B bill, it now reads Sectional Title Schemes Act, means the Sectional Title Schemes Management Act. And we're removing the word 2010, and we are now inserting 2011, and then open brackets, Act number 8 of 2011, close brackets. Chairperson, the next amendment that members agreed to was that clause 3 of the introduced bill be rejected, and that is reflected in the B bill. That previous clause is deleted, and it has now been renumbered. The B bill has now been renumbered. So it just moves up. The previous clause 4 becomes the clause 3 in the B bill. The next amendment is to clause 16. So because we've deleted clause 3, the clauses in the B bill have been renumbered, and your clause 16 becomes your clause 15 in the Bible. And as members would see, the amendment as agreed to is now reflected in the Bible, and it reads Clause 15, Section 54 of the Principal Act is hereby amended, A, by the substitution in subsection 2C for paragraph Roman 1 of the following subparagraph 1, and the word a conveyancer will be removed, and it will now read two conveyancers nominated by, and the following words have been removed: Executive Council of the Law Society of the Republic of the Republic, and it will read South African Legal Practice Council. Then, as you can see, paragraph B, by the deletion of subsection 2C of subparagraph Roman numeral 5C, but the insertion in subsection 2C of the word "and" at the end of the subparagraph Roman 6, and the addition of the following subparagraph: an officer occupying an office mentioned in section 2(1)(b) of the Deeds Registration Act, alternatively an officer contemplated in section 2(1)(c) of the Act. And the last is D, by the insertion after subsection 9 of the following subsection: 9 capital A, the provisions of subsection 6, 7, 8, and 9 are, with the necessary changes, applicable to the appointment of an alternate member. And Chairperson, the next clause in the A list was clause 18, and that clause has been removed and the clauses have been renumbered. And if we go back to the long title, the amendments to the long title are now reflected. We've removed those parts of the A title that are not relevant because the committee has deleted certain clauses. So the clause now reads, to amend Sectional Titles Act 1986 as to amend certain definitions, to provide for the developer to answer questions put to the developer by the agent of the leases, to further provide for the amendment of sectional plans in respect of exclusive use areas, to further provide for the amendments and cancellation of a sectional plan upon an order of the court, to provide for the noting of a title deed in respect of the lapsing of the reservation in terms of section 25, to provide for a release of part of the common property with the consent of the holders of the registered real rights, to amend the provisions relating to the alienation of common property, to further provide for the cancellation of a mortgage section and a mortgage exclusive use area, to also provide for the developer to submit a plan for subdivision or consolidation to the Surveyor General for approval to subdivide, consolidate, and to extend a section, to extend the registration of subdivision of a section, the consolidation of sections, and the extension of sections to a developer, to provide a document for the filing of the replacement documentation in respect of the lost or destroyed documentation, to amend the provisions relating to the extension of a scheme to membership of the sectional title regulation, to amend the provisions relating to participation quotas of sections, to regulate the membership of the Sectional Titles Regulation Board, and to provide for matters connected therewith. So, Chairperson, those were the amendments as agreed to by the committee, and they are reflected in the Bible. Stemming from that, we've also made changes to the objects memo, so that is merely to align it with the amendments that have now been agreed to by the committee. So we made amendments to the objects memo there, and to we removed clause 3 and clause 18, and we made amendments to clause 16 to now reflect the new purpose of the sections. That is now your clause 15. So, Chairperson, those were the amendments as agreed to by the committee. If the committee is fine with that, then the Chairperson can proceed to do the clause by clause of the Bible. Thank you, Chairperson.
Thank you, Mamusu and Isaac, for taking us through the amendments that have been affected by the committee. Honorable members, there's your bill list as read by our parliamentary legal advisor, Mamusuen Isaac. Is there any further input? Honorable members have picked up on what she has presented. If it is as if the changes are as reflected per the input of the honorable members, can I then request for removal? Maklape?
Thanks, Chair. Chair, I think all the amendments are reflected in the bill list, and I would move that we continue with the adoption clause by clause. Thanks.
Thank you, Honorable Klape. Honorable members, do I have a seconder so we can move and read the clauses clause by clause?
Chairperson, my hand is up. Maybe you're not seeing my hand today.
I wasn't seeing it, Honorable Stein. Please go ahead.
That's fine. Chair, I think it reflects the discussions of what we had. So I propose that we move to the clause by clause, Chair. Thank you.
Thank you, Honorable Stein, for seconding that we move ahead with clause by clause. I will, honorable members, go through the bill clause by clause and request the Secretariat to assist us in navigating through the bill. It reads as follows: Sectional Titles Amendment Bill, as amended by the Portfolio Committee on Agriculture, Land Reform and Rural Development in the National Assembly. The English text is the official text of the bill, and it is, honorable members, made available in all official languages of the Republic. Minister of Agriculture, Land Reform and Rural Development, B 31B 2020. And the general explanation, okay, we move straight to the bill. The long explanation, honorable members, reads as follows: Bill to amend the Sectional Titles Act 1986 so as to amend certain definitions to provide for the developer to answer questions put to the developer by the agents of the lessees, to further provide for the amendment of sectional plans in respect of exclusive use areas, to further provide for the amendment and cancellation of a sectional plan upon an order of court, to provide for the noting of a title deed in respect of the lapsing of a reservation in terms of sections 25, to provide for a lease of part of the common property with consent of holders of registered real rights, to amend the provisions relating to the alienation of common property, to further provide for the cancellation of a mortgaged section and mortgaged exclusive use area, to also provide for a developer to submit a plan for subdivision or consolidation to the Survey General for approval to subdivide, consolidate, and to extend a section, to extend the registration of subdivisions of a section, the consolidation of sections, and the extensions of sections to a developer, to provide for the filing of replacement documentation in respect of lost or destroyed documentation, to amend the provisions relating to the extension of a scheme, to amend the provisions relating to participation quotas of sections, to regulate the membership of the Sectional Titles Regulation Board, and to provide for matters connected therewithin, be it enacted by Parliament of the
Chair.
Republic. Yes.
Yes, Chair, you can now put the long, after each clause, put it to the members for them to
Okay.
adopt each clause. Thank you.
Okay, thank you for that. Honorable members, there's the long definition of the bill as read to you. Can I have a mover for the adoption of the definition? Honorable Clapper. Honorable Clapper. We challenged with the network today. When you have a mover, honorable members, I'm looking for hands. Honorable Priet.
Chairperson, I move for the adoption of the long title.
Thank you, Honorable Priet. Moves for the adoption of the long definition. Can we have a seconder, Honorable Mahlo?
Chairman, I second. Thank you.
Thank you, Honorable Mahlo. Let us then move, honorable members, be it enacted by the Parliament of the Republic of South Africa as follows. Amendment of Section 1 of Act 95 of 1986, as amended by Section 1 of Act 63 of 1991, Section 1 and Section 11 of Act 7 of 1992, Section 1 of Act 15 of 1993, Section 1 of Act 44 of 1997, Proclamation number R9 of 1997, Section 1 of Act 29 of 2003, Section 1 of Act 7 of 2005, Section 1 of Act 6 of 2006, Section 1 of Act 11 of 2010, Section 20 of Act 8 of 2011, and Section 1 of Act 33 of 2013. Honorable members and all those that are on the platform, can I ask you to mute your microphones? Baungwenya, can you please mute your microphone? Baungwenya, please mute your microphone. Thank you. Honorable members, if we then move to clause 1, reads as follows. Section 1 of the Sectional Titles Act 1986, Act number 95 of 1986, herein after referred to as the Principal Act, is hereby amended. A, by the substitution for the definition of exclusive use area of the following definition. Exclusive use area means a part or parts of the common property for the exclusive use by the owner or owners of one or more sections, or by the occupant or occupants thereof recognized by law and contemplated in this act. B, the substitution for the definition of Sectional Titles Schemes Management Act of the following definition. Sectional Title Schemes Management Act means Sectional Title Schemes Management Act 2010, 2011, Act number 8 of 2011. Can we move up? Is that the end of clause 1?
Yes, Chairperson.
Thank you. Honorable members, there's clause 1 has been read to the committee. Can we have a mover for the adoption of clause 1? I'm looking for hands, honorable members.
Honorable Chair.
Honorable Tapa, please go ahead.
Honorable Chair, I move for the adoption of clause 1.
Thank you, Honorable Tapa. Moves for the adoption of clause 1. Can we have a second, honorable members? And we have a second, honorable members.
Chairperson, I will second that.
Akbare Breed, Dankie. Seconds for the adoption of the clause 1. We'll proceed, honorable members, and read clause 2, which reads as follows: the amendment of section 4 of Act 95 of 1986 as amended by section 2 of Act 63 of 1991, section 2 of Act 15 of 1993, sections 2 and 30 of Act 44 of 1997, section 2 of Act 29 of 2003, and section 2 of Act 33 of 2013 reads as follows: clause 2. Section 4 of the Principal Act is hereby amended by the substitution in the subsection 3 for paragraphs B of the following paragraph. B, a meeting contemplated in paragraph A, Roman numerical 1, has been amended and the developer has been available thereat to provide the particulars contemplated in the said paragraph and has answered all reasonable questions put to the developer by the lessees or their respective agents present, provided that a developer need not comply with this subsection if all such lessees have stated in writing that they are aware of their rights, which shall also be set out in such statement, and that they do not wish to purchase the proposed units which they occupy, and a conveyancer has certified in writing that such statement have been received in respect of all the units in question, provided further that a share block company applying for the approval of a development scheme need not comply with the requirements of this subsection if that share block company has, within a period of 2 years before such application, already complied with Section 11A of the Share Blocks Control Act 1980, Act number 59 of 1980. Honorable members, that is clause 2 of the Sectional Titles Amendment Bill. Can we have a mover, honorable members, for the adoption of clause 2? Honorable Kapa.
Thank you, Honorable Chair. I move for the adoption of clause 2.
Thank you, Honorable Kapa moves for the adoption of clause 2. Can we have a seconder, honorable members? Honorable Matlo.
Chair, I second the mover. Thank you.
Honorable Matlo seconds the adoption of clause 2. We move on then to clause 3, honorable members, which reads as follows. Amendment of section 14 of Act 95 of 1986 as amended by section 8 of Act 63 of 1991, section 4 of Act 7 of 1992, section 5 of Act 11 of 2010, and section 3 of Act 33 of 2013. Clause 3 reads as follows. Section 14 of the Principal Act is hereby amended. A, by the substitution for subsection 3 of the following subsection. 3, if in the opinion of the Surveyor General, any person could be prejudiced by an incorrect sectional plan, he or she shall advise the registrar as to which sections or exclusive use area are affected by any such defect in question, and thereafter no transfer of such section and its undivided share in the common property or the registration of a real right therein, or the cession of an exclusive use area shall be registered until the defect in the sectional plan has been rectified, unless the registrar is certified that the delay in causing the defective sectional plan to be rectified will cause undue hardship, and the person in whose favor transfer of the section and its undivided share in the common property or of a real right therein, or cession of an exclusive use area is to be registered, consent in writing to the transfer or other registration being effected prior to the rectification of the defect. B, by the substitution for subsection 5 of the following subsection. 5, the Surveyor General shall advise the registrar and the local authority of any alteration, amendment, or substitution of a sectional plan in terms of subsection 1, which affects the description or extent of any section or exclusive use area, and thereupon the registrar shall make the necessary endorsement in reflecting any change of description or extent upon the deeds registry, copy of the sectional titles deed, and upon any other registered document affected by such change, and shall likewise endorse the owner's or holder's copy of that sectional titles deed or any such other registered document whenever subsequently lodged at the deeds registry for any purpose. And C, by the addition in subsection 8 of the following paragraph, the existing subsection becoming paragraph A. B, the provisions of section 49, subsection 3 to section 49, subsection 5 apply with the necessary changes in instances where a body corporate is in existence upon cancellation of the sectional plan by an order of court. That concludes clause 4, clause 3, honorable members. Can we have a mover for the adoption of clause 3 as read to the committee? Honorable Mahlo.
Honorable Chair, I move for the adoption of the clause as read. Thank you.
Thank you, Honorable Mahlo moves for the adoption of clause 3 as read to the committee. Can we have a seconder, honorable members? Honorable Kapa.
Thank you, Honorable Chair. I move the motion for the adoption of clause 3.
Thank you, Honorable Kapa moves for the adoption of clause 3. We now move to clause 4, honorable members, which reads as follows. Amendment of section 15B of Act 95 of 1986, as amended by section 10 of Act 63 of 1991, section 10 of Act 44 of 1997, section 2 of Act 6 of 2006, section 6 of Act 11 of 2010, section 20 of Act 8 of 2011, and section 4 of Act 33 of 2013. Section 4 reads as follows. Section 15B of the Principal Act is hereby amended by the deletion in subsection 1 of the word "and" at the end of paragraph C, the insertion of the word "and" at the end of paragraph D, and the addition of the following paragraph E. The registrar must note the lapsing on the title deed of the right to reserve, of the right so reserved, if available, where a right in respect of a reservation in terms of section 25 has lapsed on application by the developer or by the body corporate in instances where the developer is no longer in existence, provided that where the title deed of the right is not available, an affidavit must be submitted by the developer or by the body corporate, as the case may be, to the effect that the title deed to such right is not available, whereupon the registrar must endorse the deeds registry duplicate thereof. And if the original title deed is at any time lodged with the registrar, he or she must make a similar endorsement thereon. Honorable members, that is clause 4 as read to the committee. Can I have a mover for the adoption of clause 4? Honorable Kapa.
Thank you, Honorable Chair. I move for the adoption of clause 4 of the bill.
Thank you, Honorable Kapa moves for the adoption of clause 4. Can I have a seconder, honorable members? Honorable Klape.
Chair, I second the move for adopting clause 4 as read. Thanks.
Thank you, Honorable Klape seconds the adoption of clause 4. Let us move, honorable members, to clause 5, which reads as follows. Amendment of section 17 of Act 95 of 1986, as amended by section 11 of Act 63 of 1991, section 11 of Act 44 of 1997, section 53 of Act 24 of 2003, section 4 of Act 29 of 2003, section 1 of Act 11 of 2005, section 5 of Act 6 of 2006, section 20 of Act 8 of 2011, and section 5 of Act 33 of 2013. 5. Section 17 of the Principal Act is hereby amended. A, by the substitution in subsection 4 for paragraph B of the following paragraph. B, where pursuant to subsection 1 it is sought to let land which forms part of the common property or a portion thereof on which a section or part of a section is erected. The registrar shall not register the lease unless it is made subject to any right which the owner of the section or part of the section may have, as well as the right of holders of real right in terms of Section 25 and Section 27. B, by the substitution for subsection 4B of the following subsection. 4B, A, where in terms of subsection 1, it is sought to alienate a portion of land or which an exclusive use area or part thereof is registered. The register shall not register the transfer unless the registration of the exclusive use area or part thereof has been cancelled with the written consent of the holder. B, the registrar shall notify the Surveyor General and local authority when the registration of an exclusive use area or part thereof has been cancelled in terms of paragraph A, and on receipt of such a notice, the Surveyor General shall make the necessary amendments on the original sectional plan and on the deeds registry copy of sectional plan. And C, by the substitution for subsection 4C of the following subsection 4C, the provisions of subsection 4B shall apply with the necessary changes where in terms of subsection 1, it is sought to alienate a portion of land on which a real right of extension in terms of section 25 subsection 1 or any part of such right is registered. The registrar shall not register the transfer unless the registration of such real right or part thereof has been cancelled with the written consent of the holder thereof. Honorable members, that's clause 5 as read to the committee. Can I have a mover for the adoption of clause 5? Honorable Klape.
Chair, I move for adoption of clause 5 as read. Thank you.
Thank you, Honorable Klape moves for the adoption of clause 5. Can we have a second, honorable members? Ambata.
Morning, Chair.
Good morning, Honorable Mbata. I was hesitant if that was you, but now that I see you, please go ahead.
I second the move, Chairperson.
Thank you, Honorable Mbata. Seconds the move to adopt clause 5. We move on, honorable members, to clause 6, which reads as follows. Substitution of section 18 of Act 95 of 1986 as amended by section 6 of Act 33 of 2013. The following section is hereby substituted for section 18 of the Principal Act. Transfer of mortgaged unit, undivided share, common property or land, and cession of mortgage lease or real right. Section 18, the provision of Section 56 and Section 57 of the Deeds Registries Act shall apply with the necessary changes to transfer of any mortgaged unit or undivided share in a unit, the cession of any mortgaged lease of a unit or undivided share in a unit, the cession of any mortgaged real right in or over a unit or an undivided share in unit, the cession of any mortgaged real right under Section 25 and Section 27 of this Act or an undivided share therein, and the transfer under Section 17 of this Act of any mortgaged common property or land or an undivided share therein, and the cancellation under Section 17 of any mortgage section and exclusive use area and real rights under Section 25. Honorable members, that is clause 6 as read to the committee. Can we have a mover for the adoption of clause 6? Any hands, honorable members?
Chair, my hand is up.
Honorable Klape.
Chair, I move for adoption of clause 6 as read. Thank you.
Thank you, Honorable Klape moves for the adoption of clause 6. Can we have a seconder, honorable members? Any seconder, honorable members?
Chair, my hand is up.
Mama Mbata, please proceed.
I second the move for adoption.
Thank you, Honorable Mbata moves for seconds the adoption of clause 6. We'll now move on, honorable members, to clause 7, which reads as follows. The amendment of Section 25 of Act 95 of 1986, as amended by Section 14 of Act 44 of 1997 and Section 20 of Act 8 of 2011. Clause 7, Section 21 of the Principal Act is hereby amended by the insertion after subsection 1 of the following subsection 1A. The provisions of subsection 1 apply with the necessary changes where a developer, prior to the establishment of a body corporate, intends to subdivide his or her section or to consolidate 2 or more sections registered in his or her name. That is clause 7, honorable members. Can we have a mover for the adoption of clause 7? Honorable Klape.
Chair, I move for adoption of section 7 as read. Thank you.
Thank you, Honorable Klape. Moves for the adoption of clause 7 as read. Can we have a seconder, honorable members? Honorable Mahlo.
Chair, I second clause 7 as read. Thank you.
Thank you, Honorable Mahlo. Seconds the adoption of clause 7 as read. Let us now move, honorable members, to clause 8, which reads as follows. Amendment of Section 22 of Act 95 of 1986, as amended by Section 12 of Act 63 of 1991 and Section 11 of Act 44 of 1997. Reads as follows, clause 8. Section 22 of the Principal Act is hereby amended. A, by the insertion after subsection 1 of the following subsection 1A, The provisions of subsection 1 apply with the necessary changes where a developer, prior to the establishment of a body corporate, wishes to register a sectional plan or subdivision of a section. B, by the insertion in subsection 2 of the following paragraph after paragraph C. C, A, any lease or other deed embodying any other real right registered against the section at the time of subdivision, if available, provided that where the lease or other deed embodying the real right is not available, any affidavit or an affidavit must be submitted by the owner or developer, as the case may be, to effect that the lease or other deed is not available, whereupon the registrar must endorse the deeds registry, duplicate thereof, and if the original lease or other deed is at any time lodged with the registrar, he or she must make a similar endorsement thereon. C, by the substitution in subsection 2 for paragraph D of the following paragraph. D, certificates of registered sectional title in the prescribed form for each of the new sections and their undivided shares in common property created by the subdivision made out in favor of the owner, or in the case of a partition in favor of the persons entitled thereto in terms of the partition agreement. D, by the deletion in subsection 2 of paragraph E, and E, by the insertion after subsection 2 of the following subsection 2A and small bracket A, where an application as contemplated in subsection 1 is made by a developer, such application must also be accompanied by an affidavit by such developer to the effect that at the end of the application, no unit in the scheme has been sold, donated, or exchanged, or if a unit was so alienated but not yet registered in the name of the acquirer, the developer had disclosed in writing to the acquirer thereof that application has been made for the registration of the sectional plan of subdivision of the relevant section. B, a deeds of alienation in which the subdivision has not been disclosed shall be voidable at the option of the acquirer. That is, honorable members, clause 8 as read to the committee. Can we have a mover for the adoption of clause 8? Honorable Mahlo.
Chair, I move for adoption of clause 8.
Thank you, Honorable Mahlo moves for the adoption of clause 8. Honorable members, can we have a seconder? Honorable Mbata.
Thank you, Chair. I second the move. Thank you.
Thank you, Honorable Mbata moves for seconds the adoption of clause 8. Let us now, honorable members, move to clause 9, which reads as follows. Amendment of section 23 of Act 95 of 1986, as amended by section 13 of Act 63 of 1991 and section 16 of Act 44 of 1997. Clause 9 reads as follows. Section 23 of the Principal Act is hereby amended. A, by the insertion after subsection 1 of the following subsection. 1A, the provisions of subsection 1 apply with the necessary changes where a developer, prior to the establishment of a body corporate wishes to register a sectional plan of consolidation of 2 or more sections. B, by the insertion of subsection 2 of the following paragraph after paragraph C. CA, any lease or other deed embodying any other real right registered against the section at the time of consolidation, if available, provided that where the lease or other deed embodying the real right is not available, an affidavit please mute your microphone. An affidavit must be submitted by the owner or developer, as the case may be, to the effect that the lease or other deed is not available, whereupon the registrar must endorse the deeds registry, duplicate thereof, and if the original lease or other deed is at any time lodged with the registrar, he or she must make a similar endorsement thereon. And C, by the insertion after subsection 2 of the following subsection, 2A, small a in bracket, where an application as contemplated in subsection 1 is made by a developer, such application must also be accompanied by an affidavit by such developer, to the effect that at the date of the application, no unit in the scheme has been sold, donated, or exchanged. Or if a unit was so alienated but not yet registered in the name of the acquirer, the developer had disclosed in writing to the acquirer thereof that application has been made for the registration of sectional plan of consolidation of the relevant sections. B, a deed of annulation in which the consolidation has not been disclosed shall be voidable at the option of the acquirer. Honorable members, that is clause 9 as read to the committee. Can we have a mover for the adoption of clause 9? Honorable Mahlo.
Chair, I'm here moving for clause 9 as read. Thank you.
Thank you. Honorable Mahlo moves for the adoption of clause 9. Can we have a seconder, honorable members? Any hands, honorable members, for a seconder?
Chair, I second the move. My gadget is failing me. I'm seconding
Thank
the
you.
move of adoption of clause 9 as read. Thanks.
Thank you, Honorable Kabe. Seconds the adoption of clause 9. We will now move to clause 10, honorable members. We just thank you. It reads as follows. Amendment of Section 24 of Act 95 of 1986, as amended by Sections 14 of Act 63 of 1991, Section 17 and Section 29 of Act 44 of 1997, Section 5 of Act 29 of 2003, Section 2 of Act 7 of 2005, Section 7 of Act 11 of 2010, Section 20 of Act 8 of 2011. Reads as follows, clause 10 reads as follows, Section 24 of the Principal Act is hereby amended. A, by the insertion after subsection 3 of the following subsection 3A, the provisions of subsection 3 apply with the necessary changes where a developer, prior to the establishment of a body corporate, intends to extend the boundaries or floor area of his or her section. B, by the deletion in subsection 6 of the word "and" at the end of paragraph D, and the insertion of the following paragraph after paragraph D. DA, any lease or other deed embodying any other real right registered against the section at the time of extension, if available, provided that where the lease or other deeds embodying the real right is not available, an affidavit must be submitted by the owner or developer, as the case may be, to the effect that the lease or other deed is not available, whereupon the registrar must endorse the deeds registry, duplicate thereof, and if the original lease or other deed is at any time lodged with the registrar, he or she must make a similar endorsement thereon. And C, by the insertion after subsection 6A of the following subsection, 6AA, small brackets A, where an application as contemplated in subsection 6 is made by a developer, such application must also be accompanied by an affidavit by such developer to the effect that at the date of the application, no unit in the scheme has been sold, donated, or exchanged, or if a unit was so alienated but not yet registered in the name of the acquirer, the developer had disclosed in writing to the acquirer thereof that application has been made for the registration of the sectional plan of extension of the relevant section. Honorable members, that is another, okay, we have B, a deed of alienation in which the extension has not been disclosed shall be voidable at the option of the acquirer. Honorable members, that is clause 10 as read to the committee. Can we have a mover for the adoption of clause 10? Honorable Kabe.
Chair, I move for adoption of clause 10 as read.
Thank you, Honorable Kabe. Moves for the adoption of clause 10 as read to the committee. Can we have a second, honorable members? Honorable Marshall.
Chair, I second the move.
Thank you, Honorable Marshall. Seconds the adoption of clause 10 as read to the committee. Honorable members, we now move to clause 11, which reads as follows. Amendment of section 25 of Act 95 of 1986, as amended by section 15 of Act 63 of 1991, section 6 of Act 7 of 1992, section 18 of Act 44 of 1997, section 6 of Act 29 of 2003, section 3 of Act 7 of 2005, section 8 and section 20 of Act 11 of 2010, section 20 of Act 8 of 2011, and section 8 of Act 33 of 2013. Clause 11 reads as follows. Section 25 of the Principal Act is hereby amended. A, by the insertion after subsection 2 of the following subsection. 2A, a registrar of deeds must, if any of the documentation referred to in subsection 2A, B, C, D, or G has been lost or destroyed on written application by the body corporate, or if a body corporate has not been established on written application by the developer, and in the prescribed form and manner, file such replacement documentation in the relevant sectional titles register. B, by the substitution in subsection 5A for paragraph A of the following paragraph. A, if the right reserved in terms of subsection 1 is exercised, the developer or his or her successor in title shall immediately after completion of the relevant unit or exclusive use area apply the registration of the relevant plan or extension and the exclusion of such unit or exclusive use area in the relevant sectional title register. C, by the substitution for subsection 6 of the following subsection. 6, if no reservation was made by the developer in terms of subsection 1, or if such a reservation was made and for any reason has lapsed, the right to extend a scheme, including land contemplated in section 26, shall vest in the body corporate, which shall be entitled, subject to this section, section 5, subsection 1B of the Sectional Titles Scheme Management Act, and after compliance with the necessary changes with the requirements of paragraphs A, B, C, D, and G of subsection 2 to obtain a certificate of real rights in the prescribed form in respect thereof, provided that the body corporate shall only exercise, alienate, or transfer such a right with the written consent of all the members of the body corporate, the mortgagees of the units and real right over the units, and the holders of the registered real right over the units in the scheme, and who shall not withhold such consent without good cause in law. D, by the substitution in the subsection 10 for paragraph C of the following paragraph. C, the certificate of real right by which the reservation in terms of subsection 1 or subsection 6 is held, together with any subsection now mortgage bond registered against the certificate of real right and the consent of the mortgagee to the substitution of the sections depicted on the sectional plan of extension and their undivided shares in the common property as security in lieu of the real right held under the certificate of real right mortgaged under the bond. E, by the substitution in subsection 10 DA for the words preceding subparagraph 1, Roman numerical letter 1 of the following words: any mortgaged bond which may be affected by, registered against the certificate of real right, together with the consent of the mortgagee to the registration of the extension of the scheme and the endorsement of such bond to the effect that it is attached to, and F, by the substitution in subsection 10 DA for paragraphs numerical letter 1 and 2 of the following paragraphs respectively, Roman numerical letter 1, each section shown on the sectional plan and its undivided share in the common property, as well as all exclusive use areas shown on the sectional plan, Roman numerical letter 3, the certificate or certificates of real right in respect of a right of exclusive use as contemplated by subsection 10D and section 27, subsection 1, and that, honorable members, concludes clause 11 as read to the committee. Can we have a mover for the adoption of clause 11? Honorable Mahlo. Your hand is
Honorable
up.
Chair, I stand to move for the adoption of.
Thank you, Honorable Mahlo moves for the adoption of clause 11 as read to the committee. Can we have a second, honorable members?
Chair, I move to second adoption of clause 11 as read. Thank you.
Thank you, Honorable Kape moves for the seconds the adoption of clause 11 as read to the committee. Honorable members, we now move to clause 12, which reads as follows. Amendment of section 26 of Act 95 of 1986 as amended by section 16 of Act 63 of 1991. Section 19 of Act 44 of 1997, Section 7 of Act 29 of 2003, Section 3 of Act 6 of 2006, and Section 20 of Act 8 of 2011. Clause 12 reads as follows, honorable members. Section 26 of the Principal Act is hereby amended by the addition of the following subsection. Subsection 8, the provisions of subsections 4 to subsection 7 apply with the necessary changes to instances where land to extend the common property is purchased or acquired by the developer. Subsection 9A, where a developer purchases or otherwise acquires land to extend the common property, an affidavit by such developer must be submitted to the registrar to the effect that at the date of purchase or acquisition of such land, no unit in the scheme has been sold, donated, or exchanged, or if a unit was so alienated but not yet registered in the name of the acquirer, the developer had disclosed in writing to the acquirer thereof that application has been made for the registration of a plan of extension of the common property. B, a deed of alienation in which the extension has not been disclosed shall be voidable at the option of the acquirer. Honorable members, that is clause 8 as read to the clause 12 as read to the committee. Can we have a mover for the adoption of clause 12? Honorable Kape.
Chair, I move for adoption of clause 12 as read. Thank you.
Thank you, Honorable Kape moves the adoption of clause 12 as read to the committee. Can we have a second, honorable members? Honorable Kape. Honorable Kape. Okay, Honorable Mahlo, your hand is also up.
Chair, I stand to second for clause 12 as read.
Thank you, Honorable Mahlo. Seconds the adoption of clause 12. We now move, honorable members, to clause 13, which reads as follows. The amendment of section 27 of Act 95 of 1986 as amended by section 17 of Act 63 of 1997, section 20 of Act 44 of 1997, section 8 of Act 29 of 2003, Section 4 of Act 7 of 2005, Section 9 of Act 11 of 2010, Section 20 of Act 8 of 2011, and Section 9 of Act 33 of 2013. Clause 13 reads as follows. Section 27 of the Principal Act is hereby amended by the insertion after subsection 5 of the following subsection. Subsection 5A, the provisions of subsection 5 apply with the necessary changes to the cancellation of a right to exclusive use of part of the common property registered in favor of a developer, provided that such right may be cancelled by the developer prior to the establishment of a body corporate, with the written consent of the mortgagees of the exclusive use area by means of registration of a unilateral notarial deed of cancellation. Honorable members, that is clause 13 as read to the committee members. Can we have a mover for the adoption of clause 13? Honorable Klape.
Chair, I move for adoption of clause 13 as read. Thank you.
Thank you. Honorable Klape moves for the adoption of clause 13 as read. Can we have a seconder, honorable members? Honorable Matlo.
Honorable Chair, thank you very much. I second.
Thank you, Honorable Matlo. Seconds the adoption of clause 13. We now move to clause 14, honorable members, which reads as follows. The amendment of section 32 of Act 95 of 1986, as amended by section 30 of Act 44 of 1997, and section 20 of Act 8 of 2011. Clause 14 reads as follows. Section 32 of the Principal Act is hereby amended. A, by the substitution of subsection 1 of the following subsection. 1, subject to the provisions of section 48, 17 of the Sectional Titles Amendment, Sectional Titles Scheme Management Act, in the case of a scheme for residential purposes only, as defined in any applicable operative town planning scheme, statutory plan, or conditions subject to which a development was approved in terms of any law. The participation quota of a section shall be a percentage expressed to 4 decimal places and arrived at by dividing the floor area correct to the nearest square meter of the section by the floor area correct to the nearest square meter of all the sections in the building or buildings comprised in the scheme. And B, by the substitution in subsection 2 of the words preceding paragraph A of the following words. Subsection 2, subject to the provisions of section 48, 17 of the Sectional Titles Scheme Management Act, in the case of a scheme other than a scheme referred to in subsection 1, the participation quota of a section shall be a percentage expressed in 4 decimal places as determined by the developer, provided that. Is that the end of clause 14? If that be, honorable members, that is clause 14
Yes,
as
Chair.
read to the committee. Can we have a mover for the adoption of clause 14? Honorable Klape.
Chair, I move for adoption of clause 14 as read. Thank you.
Thank you, Honorable Kape. Moves for the adoption of clause 14 as read. Can we have a second, honorable members? Honorable Mahlo.
Chair, I second as indicated. Thank you.
Thank you, Honorable Mahlo. Seconds the adoption of clause 14. We now move, honorable members, to clause 15, which reads as follows. Amendment of sections 54 of Act 95 of 1986 as amended by section 22 of Act 63 of 1991, sections 11 of Act 7 of 1992, section 26 of Act 44 of 1997, section 13 of Act 11 of 2011, and section 8 of Act 4 of 2011. Clause 15 reads as follows. Section 54 of the Principal Act is hereby amended, A, by the substitution in subsection 2C for subparagraph numerical letter 1 of the following subparagraph, Roman numerical letter 1, a conveyancer, two conveyancers nominated by the Executive Council of the Law Society of the Republic of South Africa, African Legal Practice Council. B, the deletion in subsection 2C of subparagraph numerical letter V, which is 5, and C, by the insertion in subsection 2C of the word "and" at the end of subparagraph VI, Roman numerical letters, which is 6, and the addition of the following subparagraph, Roman numerical letter VII or V11, which is 7 in Roman numerical letters, an officer occupying an office mentioned in subsection 2, subsection 1B of the Deeds Registries Act. Alternatively, an officer contemplated in section 2, subsection 1C of the said Act. And D, by the insertion after subsection 9 of the following subsection 9A, the provisions of subsections 6, 7, 8, and subsection 9 are, with the necessary changes, applicable to the appointment of an alternate member. Honorable members, that is clause 15 as read to the committee. Can we have a mover for the adoption of clause 15?
Chair, I move for adoption of clause 15 as read. Thank you.
Thank you, Honorable Kape. Moves for the adoption of clause 15. And we have a second, honorable members. Honorable Mahlo.
Chair, I second clause 15 as read.
Thank you, Honorable Mahlo. Seconds the clause 15 as read. We now move, honorable members, to clause 16, which reads as follows. The amendment of section 55 of Act 95 of 1986 as amended by section 23 of Act 63 of 1991, section 10 of Act 7 of 1992, section 3 of Act 15 of 1993, section 17 of Act 170 of 1993, section 27 of Act 44 of 1997, and section 20 of Act 8 of 2011. Clause 16 reads as follows. Section 55 of the Principal Act is hereby amended by the addition of the following subsection, the existing section becoming subsection 1, subsection 2, regulations made by the minister shall be published in the Gazette at least 1 month before the date specified in the relevant notice as the date of commencement thereof. Honorable members, that is clause 16 as read to the committee. Can we have a mover on the adoption of clause 16? Honorable Mahlo. Honorable Mahlo, your hand is up.
Chair, I will stand in for her. Maybe she's having network challenge now. I move that we adopt clause 16 as read. Thank you.
Thank you. Honorable Kape moves for the adoption of clause 16 as read. Can we have a seconder, honorable members? Honorable Mbata.
Thank you, Chair. I second the move for the adoption.
Thank you. Honorable Mamumbata moves, seconds the adoption of clause 16 as read to the committee. We now come to clause 17, honorable members, which reads as follows. This act is called the Sectional Titles Amendment Act 2020 and comes into operation on the date of publication in the Gazette. That is clause 17, honorable members. Can we have a mover for the adoption of clause 17?
Chair, I move for adoption of clause 17 as read. Thank you.
Thank you, Honorable Kape moves for the adoption of clause 17. Can we have a seconder, honorable members? Honorable Mbata.
Thank you, Chair. I second the move for adoption.
Thank you, Honorable Mbata. Seconds the adoption of clause 17 as read to the committee. Honorable members, that concludes the clauses that we had to go through on the B bill. I now put the B bill of Sectional Titles Amendment Bill in its totality to the committee for adoption. Can we have a mover, honorable members? Honorable Kape.
Chair, I move for adoption of the bill list that we adopted. Thank you.
Thank you, Honorable Kape moves for the B list of the Sectional Titles Amendment Bill to be adopted in its entirety. Honorable members, can we have a seconder? Honorable Mbata.
Thank you, Chair. I second the move for the adoption.
Thank you. Honorable Stein, is that a hand? Were you wanting to second?
Chairperson, I just wanted to say that we are not against, but we reserve our rights until the caucus have made a decision. Chair, that is the position of the DA at the moment. Thank you.
And when you're referring to a caucus?
For the Democratic Alliance. Thank you, Chair.
Okay. Now, thank you, Honorable Stein, for the raising that. Honorable members, that concludes our work as far as the work we had in dealing with the B list of the Sectional Titles Amendment Bill. Mamukakaza, Manyamza, do we have any minutes to adopt? Dr. Matias, I see your hand.
Yeah, well, thanks,
You may.
Honorable Chair. Greetings to you and to the colleagues.
Greetings to you, Ndati.
Yes. Well, look, Honorable Chair, the bill, just like many other bills that has got to do with property and ownership of property, hinges on the fundamental, foundational pillar of land ownership, and especially land ownership under the custodianship of the state. To an extent that we don't have that arrangement in the country. The land is still owned privately, and that be the case, the land administration tenure system in this country is subject to colonial and all sorts of exclusionary mechanisms. We found it difficult for the economic freedom fighters to agree with a bill of this nature until land entirely is transferred to the ownership of the state for common use. Thank you so much.
Thank you, Dr. Matias. You are duly noted. Honorable members, before me is, or before the committees, the report of the Portfolio Committee on Agricultural and Reform and Rural Development on Sectional Titles Amendment Bill, B31 2020 in the National Assembly, Section 76, which is dated the 10th of September 2021. And it reads as follows. The Portfolio Committee on Agricultural and Reform and Rural Development, that being the Portfolio Committee, having considered the Sectional Titles Amendment Bill, B31 2020, in the National Assembly on Section 76, classified by the joint tagging mechanism as a Section 76 bill and referred to it, reports with amendments, B31A 2020. The Sectional Titles Amendment Bill, B31 2020, the bill was introduced in the National Assembly on the 2nd of November 2020. The bill seeks to amend certain provisions of the Sectional Titles Act 1986, Act number 95 of 1986, being the principal act. The Portfolio Committee, having deliberated on the content of the bill, realized that, can we move up? No. Bring it lower. Please move with us. We're still on that paragraph. Yes, thank you. Realized that it was necessary to amend provisions of the Principal Act, which were not included in the bill as introduced. Further, the Portfolio Committee requests permission to amend other sections in the Sectional Titles Act 1986, Act number 95 of 1986, other than what is amended through the bill as introduced. Specifically, it sought to amend Section 54, subsection 2C of the Principal Act in order to remove a requirement for the Sectional Titles Regulation Board to include 2 persons having special knowledge of sectional title development schemes. The requirement is no longer necessary as the Sectional Title Scheme Management Act 2011, Act number 8 of 2011, now regulates and manages sectional title schemes. The National Assembly, having considered the request, granted permission to amend provisions of the Principal Act, which were not included in the bill, as introduced on Thursday, the 9th of September, 2021. The Portfolio Committee concluded the deliberations on the bill and reports the bill with amendments agreed to as follows. Clause 1, on page 3 in line 2, after off, to omit 2011 and to substitute 2011. Clause 3, clause rejected. Clause 16 on page 9 from line 4 to omit clause 16 and to substitute. Clause 16, section 54 of the Principal Act is hereby amended. A, by the substitution in subsection 2C for subparagraph numerical letter 1 of the following subparagraph. Roman numerical letter 1, a conveyancer, 2 conveyancers nominated by the Executive Council of the Law Society of the Republic of South Africa, African Legal Practice Council. B, by the deletion in subsection 2C of subparagraph numerical letter V, which is 5, and C, by the insertion in subsection 2C of the word "and" at the end of subparagraph numerical letter VI, which is 6, and the addition of the following subparagraph. VII numerical Roman letter, which is 7, an officer occupying an office mentioned in subsection 2(1), subsection 1(b) of the Deeds Registries Act, alternatively an officer contemplated in section 2, subsection 1(c) of the said Act, and D, by the insertion after subsection 7 of the following subsection. 9A, the provisions of subsection 6, 7, 8, and 9 are with the necessary changes applicable to the appointment of an alternate member. Clause 18, clause rejected. The long title on page 2, to omit the long title of the bill and to substitute it as follows. To amend the Sectional Titles Act 1986 so as to amend certain definitions to provide for the developer to answer questions put to the developer by the agents of the lessees, to further propose for the amendment of sectional plans in respect of exclusive use area, to further provide for the amendment and cancellation of sectional plan upon an order of court, to provide for the noting of a title deed in respect of the lapsing of a reservation in terms of section 25, to provide for a lease of part of the common property for the consent of the holder of registered real rights, to amend the provisions relating to the alienation of common property, to further provide for the cancellation of the mortgage section and mortgage exclusive use area, to also provide for the developer to submit a plan for subdivision on consolidation of Surveyor General for the approval of subdivided to subdivide, consolidate, and to extend a section, to extend the registration of subdivision of a section, the consolidation of sections, and to the extension of sections to a developer, to provide for the filing or replacement documentation in respect of loss or destroyed documentation, to amend the provisions relating to the extension of a scheme, to amend the provisions relating to the participation quotas of sections, to regulate the membership of the Sectional Titles Regulations Board, and to provide for matters connected therewith. That we may move on. Who's that? Honorable members, can we mute our microphones? Not in a concert, eh? Please mute your microphones. That, honorable members, is the report to be considered. Can I put that to the committee for adoption? Have a hand, honorable members. Honorable Klape.
Chair, I move for adoption of the report as read. Thank you.
Thank you, Honorable Klape moves for the adoption of the report as read to the committee. Honorable members, can we have a seconder? Honorable Mbata.
Thank you, Chair. I second the move.
Thank you, Honorable Mbata. Seconds the adoption of the report of the committee. Honorable members, we now move to our last item of our agenda, that being the adoption of minutes. Can we move to the minutes of the 3rd of September 2021? Page 1. Page 2. Page 3. Page 4. Page 5. Honorable members, can we have a mover for the adoption of the minutes of the 3rd of September 2021? Honorable Klape.
Chair, I move for adoption of the minutes of 3rd September 2021 as a true reflection of the business that transpired on that day. Thank you.
Thank you, Honorable Kape. Moves for the adoption of the minutes of the 3rd of September 2021. Can we have a second, honorable members? Agbare Breed.
Dankie, voorsitter. Ek sal dit sekondeer om die notule te aanvaar as 'n ware refleksie van daardie vergadering.
Baie dankie, Agbare Breed, for seconding for the adoption of the minutes of the 3rd of September 2021. Any matters arising, honorable members? Page 1. Page 2. Page 3. Page 4. Page 5. With no matters arising, honorable members, the minutes of the 3rd of September 2021 have been duly adopted. Any other further business of the committee? Do we have any more minutes? Since we are out of time.
No, Chair. Thank you.
No, Chair, we
That's
don't have
the
any
last-
other minutes.
All right, honorable members, let us thank you for affording us the opportunity to get through the bill list. And we would like to thank our legal advisor, Musuen Isaac, for having assisted us in navigating through that. And thank the officials of the department who attended the meeting, Mamu Reynolds, and other officials of the department who were with us. We thank you for attending this session, honorable members. Without keeping you, I know the sitting in the National Assembly has started at 10. We will now adjourn this meeting, but please enjoy the rest of the day and a great weekend ahead. Some time spent with your loved ones and continue to stay safe during this COVID pandemic. Wear your mask, sanitize, and adhere to social distances. Stay well. The meeting is adjourned.